realize how difficult it is for us at this stage to start learning all this.
There's a little issue of the back hardware so much because the others are all here.
It's a cat.
Let me just
Yes, just give us a broad framework.
Just broad framework. What the issue is the following. Kindly don't refer to any paperwork. I just explained to you about it. But this all started on the 20th of June, when in the course of the MLC elections, a seat that should have come to the Shiv Sena, we lost to the other party. That happened on the 20th of June. So on the 21st of June, a meeting was called of all the legislative members of the party. And many of them did not attend. And meantime, many of them had gone to Ahmedabad and thereafter they went to Guwahati. So obviously, they're obviously not in tune or in alignment with the party itself. So we said that if you do not attend the meeting, there will be consequences. Now, this continued. They did several things between 21st of June. And ultimately, they said that we said, okay, since you have not participated in these proceedings, we remove you. I won't go into the dates. I'm just broadly telling you, Lordship Smith. And ultimately, they were removed from the post that they occupied in the Legislative Assembly itself. They in turn said that you are no longer a leader of the party. We have a whip now. They all appointed their own whip later. Those all things happened between 21st of June. And when ultimately, on the 29th we filed disqualification applications on the 29th of June, which is a very important day. No, hold on. On the 29th of June, which is a very important day. But on the 29th of June, they came here and they wanted to form a separate government in alignment with the BJP. And so, this court, we challenged all that, and this court passed an order on the 29th of June. Kindly note that. Between 21st and 29th of June, whatever happened, I'll tell you later. But 21st of June, it started, and on 29th of June, this court passed an important order saying, given our thoughtful consideration of the diverse submissions, we do not find any ground to stay the convening of the special session of the Maharashtra Vidhan Sabha on the 30th of June. Tomorrow, that is 11 a.m., with the only agenda of a trust vote. The proceedings of the trust vote to be convened on the 30th of June shall be subject to the final outcome of the instant writ petition, as well as the writ petitions referred to above. What happened after the 29th of June in the assembly, the swearing in of the chief minister, the forming of the cabinet, functioning of the government, passing of the trust, everything is subject to the outcome of these petitions. Which means the office of the chief minister is under a cloud. Which means what happened in the assembly is under a cloud. And that will be determined by your lordships when your lordships decide the petition. Then mark the third date, which is the most important day. It is the 19th of July 2022. On the 19th of July 2022, Eknath Shinde alone moved the election commissioner. So, Malas, it is clear, therefore, that till the 19th of July, they had not moved the election commission. Everything prior to that is subject to the outcome of this petition. He is now submitted.
Mr. Sibal, when Mr. Shinde moves the election commission, in what capacity does he move the
We
election
have
commission?
put him out of the party. He has already given up membership of the party under the 10th schedule because
No,
of his qualifications.
when he moves, does he move in his capacity as an elected member of the legislature,
Yes.
or does he move in his capacity as a member of the party?
No, as a member of the legislature. He says that I am the party. This is the whole question, brothers. How will your lordship decide the election matter, brothers, in the context of his moving the election commission and declare himself? You will have to first decide his status. That status will be.
Mr. Sibal, he can move only as a member of the party.
No. Brothers.
He has to be.
Please understand, brothers. Sadhically, what your lordship has held is, brothers, that several layers. It has to be counted as to who is the party. And if he is disqualified as a member of the legislature, how will that dare be counted by the election commission? Legislative majority. It can't be done. Election commission can't go into matters, brothers, which are kindly said. The 1968 Simples Order, brothers, happened in 1968, where in 1985. He says, herein, petitioner so and so, senior leader of the Sena Legislative Party and current Chief Minister of the state of Maharashtra, which is all under cloud by orders of this court on 29th of June. I challenge the very locus of the person, brothers, to move the election commission. Very locus is under challenge.
Which powers of the election commission are being invoked when he moved this application under 19.622? Is it under the symbols order or
Yes,
or 10? It's under the symbols order.
yes, it's under the Simples Order.
So Sadiq Ali 9.
Yes, Sadiq Ali. And Sadiq Ali was at a time when the 10th schedule was not there.
That's right. That's right. That's right.
And this is the very
That is
question
an
that the lordships have heard in the reference. That's the very question referred. Now, if you refer the very question, that means there's a prima facie issue to be decided. Now, my friend is
Mr.
asking.
Sibal, the mere fact that there is a reference which has been made does not stall a constitutional authority from taking recourse to its powers under the law.
But this is also.
Because you're right, that one of the issues which has been framed is the power of the EC to decide upon a split in a party.
Yes.
But that by itself and per se will not really restrain the authority from proceeding ahead if it has authority to decide that under the law.
I don't dispute that fact, but I'm saying prior to that, there are disqualification petitions.
So we got your point. Your point really is that on the 29th of June 2022, when this court passed an order, it made the trust vote was not stayed, but it said this would be subject to the outcome of the petitions.
That's right.
Therefore, according to the office of the CM, the proceedings in the assembly are all under really a cloud, or they are subject to the decision of the petition.
Correct.
And therefore, according to you, the proceedings before the ECI are an offshoot of what has happened before. Therefore, they shouldn't go on pending the disposal of the reference. That really is the sum and substance of your argument.
Broadly, that's what I want to submit to your Lord.
Yes.
Now, can kindly look at it this way. In the meantime, under the 10th schedule, they are members of the original political party. This is very important. 10th schedule does not recognize a split. It used to recognize a split, brothers, when para 3 was there. But
Post 2003 para 3 go.
1st of January 2004, it was removed.
Original political party as legislators or as members.
Yes.
Legislators.
Correct. Therefore, Manoj, the original
That's under question.
Yes. Now, Manoj, that means he is a member of the original political party. Now, if he is a member of the original political party, and there is an issue of disqualification that is pending, whether it's pending or not, that's another issue. That again will have to be looked at. Then, Manoj, if he is disqualified, having voluntarily given up membership of the party under 21A, and having violated the whip under 21B, this all happened prior to 19th of July, when he moved the Election Commission. And your Lordship knows, mothers, in Rajendra Rana, your Lordships have held, the date of the decision will relate back to the act of disqualification. The day when that act took place. Kindly have a look at the 10th schedule with me. The Lordship knows, as a matter of law, that when any legislative party and members of the legislative party who are members of the House, the Speaker of the Assembly is conveyed those who are office bearers within the House, namely the whip. Who is the whip? That's conveyed to the Speaker. The whip, the chief whip, they continue to be members of the original political party while that whip is operating. They can't claim themselves to be a faction. But the 10th schedule doesn't recognize that. Election Commission does. The 10th schedule does not. If you say that you are a separate faction while you are a member of the original political party, according to me, you have given up membership of the party. There's nothing more to be done. Because all of these are admitted documents. This is not evident.
Therefore, Mr. Sibal, the position really is this, that the 10th schedule post 1/1/2004 does not recognize a faction, or the 1/3 split which it recognized prior to 1/1/2004 is now no longer recognized by the 10th schedule. On the other hand, you do have the 1968 order, the symbols order, which contemplates that there could be more than one faction of a political party. Now, the 1968 order governs a political party. The ambit of the disqualification provisions of the 10th schedule is the legislative party, the legislature party, right? Because the speaker, in the course of his authority to decide whether there is a disqualification or otherwise, cannot let in evidence saliente to decide as to whether a group of persons are or are not members of the wider political unit called the political party.
No, it does. It does.
That is
21A.
Can the speaker, for instance,
Yes.
we note from the written submissions, we are putting this to you because now we have the benefit of seeing the written submissions which have been formulated earlier.
Correct.
They say, for instance, that we have produced 1.5 lakh affidavits of members of the party saying that there is a faction which is represented by them. Now, does the speaker have the power to let in evidence to decide this process, which would otherwise fall within the ambit of the EC?
No.
Now, therefore, we have to define, even for the purposes of your interim application, what is the ambit of the jurisdiction of the speaker on the one hand, and what is the ambit on the other hand of the jurisdiction of the election commission?
Correct.
In terms of the symbol order.
Right.
Because the political unit or the political party is a much wider configuration than the legislative unit of that party, which consists of the elected members.
I'm not arguing with us.
Now, does it dispute in regard to the former
Yes.
or the legislative party
Yes.
affect the authority of the election commission to decide the latter?
Yes.
That is really the heart of the matter that we have.
I will answer that immediately. But let's now see what.
Let's have a look at the 10th schedule. We'll
Yes,
bring
what
some
is the
clarity to our
jurisdiction of the
thought
speaker?
process.
Look at 2(1)(a).
2(1)(a), right?
First, let's see the definition. First, look at 1(b), legislature parties. The definition of that. 1(b). Legislature party in relation to a member of a house belonging to any political party in accordance with the provisions of paragraph 2. Paragraph 4 means, paragraph 3 is omitted if you notice. Means the group consisting of all the members of that house for the time being belonging to that party in accordance with the said provisions.
Member of the house is also.
Member of the house is very important.
That's
And it says, it uses the expression member of a house and member of that house
that's
on two occasions.
that's
So legislature party in relation to a member of a house
correct.
belonging to any political party.
That political.
So it distinguishes it says any political party in the first part.
Yes.
So
Then-
the definition distinguishes between a member of a house belonging to any political party
correct.
with the group consisting of all the members of that house for the time being belonging to that political
That's
party.
correct. So, Malad, if it is
And
Shiv
group
Sena,
of that house.
that house. If it is Shiv Sena, it is Shiv Sena. If it's BJP, it's BJP. Because they have fought the election on a BJP symbol or a Shiv Sena symbol, and therefore they belong to that political party.
So we'll really have to then look at what is the ambit of the disqualification provisions and then contrast it or see if there is an overlap with the
That's right.
1968.
That's the exercise. That's why I said that if ultimately we have to decide all this, we are really going into.
So really the ambit in our eye is short. So according to you, one does spill over onto the other.
Yes.
You can't decide that as the election commission without having to comment on
That's-
the disqualification, which is an issue pending before the Supreme.
yes. This is the point.
That is the point.
Now, kindly see
Now let's see 2(1)(a).
Yeah, no. First, see
Yeah.
three, Malad. Original political party, not 2(1)(a).
1C.
1(c). Original political party in relation to a member of a house means the political party to which he belongs for the purposes of 2(1). So he belongs to the Shiv Sena. He is under the discipline of the Shiv Sena, under the control of the Shiv Sena, within the house. He has no other persona. Can't be a faction.
Being a member of the political party,
Yes,
he is a member of the house.
that's good.
The relationship is with respect to his membership in the house.
With reference to the political party which set him up as a member.
That's the,
That's correct.
but the
So,
schedule,
in fact, Malad, this is the first time in the Constitution that the term political party is used. Nowhere else in the Constitution
first time.
you find that expression. Now,
In fact, the classical books on constitutional jurisprudence in India all mention that the expression political party has not been defined anywhere at all.
luckily we know something
First
about
time it is in the symbols order, which predates 10th schedule.
Now see Malas 2.1. Subject to the provisions of 4 and 5. Again, Malas 3 is missing. A member of a house belonging to any political party. Again, the word any is used. Shall be disqualified for being a member of the house if he has voluntarily given up membership of such political party, not the house. If you're asking an example, I belong to one party, been elected on the symbol of that party. I go with a leader of another party to the governor and say, meet him and say, please call the house for the purposes of determining who has the majority. Just give you an example. That act alone will visit me with consequences under 2.1. Your lordship must.
Yes, it will go. Look at it from this angle. If there is a disciplinary proceeding against a member of a political party, if disciplinary proceedings against the member of a political party and the political party expels him, what is the bearing of that so far as his presence in the house? In Amar Singh, they said he will sit only as an unattached member.
Yes,
So therefore, whatever happens in the political party will have no bearing on his position so far as the house is concerned. So he continues to sit as an MLA, but as an unattached member.
Yes.
So therefore, where does the convergence of symbols order and 10th schedule?
Well, that will not impact the symbols order at all.
No, I'm saying where does that will not impact.
Yes.
But political party's decision is not impacting 10th schedule. And his removal from the party.
Removal is not voluntary. This is the problem.
That's right.
Yeah.
But still his presence as a
But
MLA continues.
even if he's disassociated from the party, he doesn't have to follow the whip of the party because he's been thrown out. So he's not subject to any discipline of the party. Because lordship will appreciate that when I am thrown out of the party, it's not my voluntary act. I am thrown out by virtue of the fact that the party does not want me for any reason. But the party can proceed for disqualification against me, but they don't do that. So the speaker then says that because you've been thrown out and I've been informed by the whip of the party that you are thrown out, therefore I'll give you a separate seat and I'll call you an unattached member. Then I am not subject to the whip at all. But then 2.1 he will not come.
Ironically, expulsions are welcome because expulsion doesn't disqualify you. You sit separately, you are expelled. So that is welcome rather than to proceed against for disqualification.
The question is how it would, Mr. Simple, the question is how it would, the disqualification would have effect on the symbol order, deciding the dispute with respect to symbol.
No, but I am member of the original political party. I have been elected on that symbol. I continue to be under the discipline of that party, which are otherwise, it has just huge consequences. Any assembly any government can be thrown out. Any government can be thrown out in this fashion. What is the constitution meant? People go to the governor and throw out a government which is duly elected by the House, by the people of the country. Is this how the 10th schedule is to work? I have never heard in the democratic world that an elected government for a period of 5 years through these machinations is toppled. Why? Because we are discussing some academic issue about jurisdiction of the election commission. See the heart of the matter. Where is this democracy going? Any government can be thrown out. And then what happens is that you have your own speaker. He will not decide the petition, the disqualification petition. and you merely
Now,
form the government.
now, Mr. Sibal, we have looked at the provisions of the 10th schedule. Could we now go to the powers of the EC? We'll, so that, we have to see the two sets of.
Just allow me.
Yes.
So, therefore, 218 deals with giving up voluntary membership for the party. Yes. And 218 if he votes or abstains from voting in such house, contrary to any direction issued by the political party. So, I am the whip. Whip says you have to vote for the speaker, this candidate for the office of the speaker. They vote for a BJP candidate. All this happens after 29th. Which is all the subject matter of this court's order. She belongs or by any person or authority authorized by it in this behalf without obtaining in either case the prior permission of such political party. Person or authority and such voting or abstention has not been condoned by such political party, person or authority within 15 days from the date of such voting or abstention. So if somebody votes contrary, it can still be condoned by the political party. What it tells you is that the political party is in control. See the expression, condoned by such political party, not by a member of the House or of the Whip. Let's kindly appreciate it this way. Legislative members of a political party function within the overall control of the political party. They are representatives of the people. They are not independent of that party. So the political party will then communicate to the chief whip, condone it. Condone what he did. He didn't vote for us, doesn't matter. We don't want to take any action against him. Or he didn't come for voting, doesn't matter. It happens many a times. But there's an umbilical cord link between the member of the legislature and the political party. They're not separate issues. Issues that your lordships will have to decide, which is what I said, ultimately those decisions will have to be taken by your lordships in the overall context. It can't possibly be, assuming whether your lordships were to, your lordships were to allow the election commission to go on, proceedings to go on. Some decision is taken, let's assume that. Right? And in the meantime, these proceedings take place and he is disqualified. What's the consequence? Issues of great moment for our democracy. Can we see, Malas? Explanation. This is also important. Explanation for the purposes of this subparagraph means an elected member of a house shall be deemed to belong to the political party, if any, by which he was set up as a candidate for election as such member. You can't say that I am a different faction now. You can't say that. That's the next point I want to urge before your lordship is this. Any defense of a member of a legislature belonging to a political party for the purposes of protecting himself from disqualification can only be available under the 10th schedule and in no other form. If I move for disqualification, which I moved much earlier, we will have defense under the 10th schedule. He cannot seek a declaration. And his only defense under the 10th schedule is a merger. There is no other defense available under the 10th schedule. Now, it is the admitted position that there is no merger. So he has no defense. Till the 19th of July, when he went to the election commission, he has no defense. Now he wants to, what does he want to do? He wants to go to the election commission and say that I am the political party. But much before that, his acts and the legality of his acts as a member of the House and as a member of the political party are in question, which has to be decided in these proceedings. What he does is, he says that I am 40, 39 plus 1, Eknath Shinde plus 39. I am a majority in the legislative wing of the party. Therefore, I don't recognize it. That's what he's saying. That he can't do under the 10th schedule.
Yes, Mr.
No, it's one point. Now your lordship asked me, what is the relationship between this and the symbols order?
Right.
Let's come.
Where is the symbols order?
Yes.
1868.
ये compilation भी होगा.
Now see the symbols order. Para 15.
Sure. Have you next it in your
Violation of statutes.
It's in our written submission.
it's in your written submissions? All right. Yes, there's a compilation by the Election Commission. Murari bhai, आपको मिला?
Page आप 493.
हम थोड़ा उठेंगे ना ज्ञान.
Yes.
सुनो.
Compilation.
When we wait.
A compilation of statutes for us, rules and research materials.
Yes.
That has everything.
You got compilation of documents from the election commission also.
Ready? Yes.
But
सुनो. iPad this.
Of our convenience compilation. Compilation of documents and
Para 15 can be taken from several compilations.
Para 15 is there, data in your written submission, para 3.2.
And also para 9, Lordship may kindly see. Para 9 at page 5.
It will remain the same. Change. Para 15 will remain the same in all these compilations.
Correct.
The gloss on para 15 may change depending on what you're reading.
Depends how you
But the
look at,
original.
how you read and how you look at.
That's correct.
No, actually, I have the copyright.
All right, we'll read paragraph 15.
Now see, when the commission is satisfied with information in its possession,
So, 1 minute.
is satisfied on information in its possession that there are rival sections or groups of a recognized political party, each of whom claims to be that party. The Commission may, after taking into account all the available facts and circumstances of the case, and hearing such representatives of the sections or groups and other persons as desire to be heard, decide that one such rival section or group or none of such rival sections or groups is that recognized political party, and the decision of the Commission shall be binding on all such rival sections or groups. So let me, see us put forth a situation where there is no dispute as far as the legislature is concerned. There are factions within the party, each of them claiming to be that party. And without any reference to what's happened in the House with us, they go to the Election Commission and say, we are the group. Election Commission can decide.
So
let's see at what point in time does paragraph 15 operate? On the date when he files this application, that is 19th of July. Correct, Mullah? Can't be before that. Even if the election commission were to decide, it could only decide on 19th of July when he moves the election commission. And as far as disqualification is concerned, it relates back to the date when he acted under the 10th schedule, contrary to either the whip or having given up membership of the party. So his status to move on the 19th of July will depend on your lordship's decision whether he stands disqualified or not, and he's voluntarily given up membership of the party. Voluntarily given up membership of the party, which is the decision of a constitutional authority, then how do we move the election commission? And the election commission has no jurisdiction to decide whether he is a member or not. Para 15 will operate when both sides agree that they are members of the party. It has to be that way. Because he's claiming that I belong to a rival faction within the party. He's claiming majority within the party. So where is the question, Manoj, of paragraph 15 operating at all in this case? Therefore, Manoj, to say that paragraph 15 is operative and is independent of all this, Manoj, with the greatest respect, Manoj, is contrary to the very scheme of the 10th schedule and the scheme of paragraph 15. Because paragraph 15 proceeds on the basis that you belong to the same political party and sections of a political party. If I have thrown you out, supposing I have thrown a person out, he can't move. He's voluntarily given up membership of the party. He can't move. And that's the decision of a constitutional authority. The election commission of India will decide much later. The question is,
Mr. Sibal, what's the next point now? We've got this part of this limb of your arguments here.
yeah. So, therefore, this is one part of it. Therefore, paragraph 15 doesn't come into play at all.
Right.
Now, let's look at it on basic principles. We are here because there's a prima facie case. Slowly, matter is pending. It is referred to a constitutional bench. Surely, the strong prima facie case, otherwise, it will not be sitting here. 2, what's the balance of convenience today? So far, the election petition has not proceeded and the matter is listed for hearing. And there is nothing that's happening. No election that's happening. In the Bombay High Court, there is a stay of the BMC election. Supreme Court.
Now, the stay on the elections to the BMC has come about as a result of which order?
Supreme Court.
The court, this court's order.
Supreme Court.
Not the Bombay High Court.
No, there is no stay at all.
There is no stay of BMC election.
In one of the submissions I read yesterday, that they have said that there was a stay for a period of 5 weeks. That's what they have said.
When they produce the order, there is no stay.
The best of all,
Hold on.
there is no stay today.
The matter is coming up tomorrow in the High Court, and the state and Maharashtra Supreme before court number 2. State is asking for time for 2 weeks.
In the Bombay High Court.
Yeah.
Oh, yeah.
Yes.
That order is passed on 22nd August 22 in SLP number 19756 of 21. I can't understand why there is a chorus of
Dr. Singhvi, SLP.
SLP 19756 of 21 by your lordship's 22nd August 22, titled Rahul Ramesh Wagh versus State of Maharashtra.
And they have asked for 2 weeks' time.
But I beg your pardon, Manoj, that's the OBC reservation matter, nothing to do with the, my learned friends are thoroughly
It's totally wrong. The last PMC elections, the state came out with an amendment that was specifically challenged by us for directed status for my learned friend is not appearing in that matter, so he doesn't know.
No, I'm talking about the matter that's coming up in the High Court tomorrow.
As far as PMC elections are concerned, there is a status quo, my lord. That order we have placed, my lord, in our return submission.
All right.
I'm just saying, Manoj,
That's for the balance of convenience. Sure.
But the matter tomorrow is about the OBC.
We'll hear you, Mr. Yadnani, we'll hear you. Let's follow some order. Yes. All right.
lot of enthusiasm moreover. That's all right. Now, the point is, what's the balance of convenience? So far, it has continued. Matter is going to be decided by your lordships, Manoj, and it will determine, all the issues will be determined.
All right. So prima facie case and balance of convenience.
And then, Manoj, irreparable injury.
Yes.
Do not decide this matter and allow the election commission to go on, and the election commission freezes the symbol. What's going to happen? It's irreparable injury. To me, without determining the issues that are pending before this court. And if those issues are decided in my favor, and you allow the election commission to proceed, see the consequences of that.
Mr. Sibbal, we've made a note of that. So, anything else, Mr. Sibbal?
Don't take time without repetition. Very brief.
Who are you appearing for, Dr. Singhvi?
Because there are 8 petitions I am appearing for the
All right.
eminent parties, because we are on this side versus that side.
And you will be characteristically brief, Mr. Dr. Singhvi.
I'm grateful because for the word characteristic.
Correct. Absolutely.
Your lordship has always rendered me speechless before I started. May I be very pointed? Well, your lordships has 4 points in the 10th schedule. The issue is narrow. Whether your lordships on a
Can you just formulate the 4 points?
Before let me do that. Today, your lordship is not hearing the matter.
Right.
Today, your lordship is deciding the correct balance of convenience to endure till such time after Diwali, your lordship hears the matter and renders judgment. That's the only issue today. Now, whereas for that, far from being unrelated, as the other side is saying, the issue is in direct collision and inextricably intertwined. That's the first point. I will demonstrate that in a minute.
Just a moment.
Direct collision and inextricably intertwined.
Yes, Dr.
Number 2, it is for that reason, and I'm not saying it's a judicial order, but it is for that reason that your lordships has advisedly, in different combinations, from 4th of August 22, made it clear that people will seek adjournment in the election commission and the matter will not go on. There have been 3 dates in between, from then to now, including one coming up later this week or next week. So it has been adjourned. That was the lordship understanding. Of course, subject to lordship adjudication today, no doubt.
Till the application was heard.
Number 3, why this inextricable intertwining and collision was? There are 4 elements of the 10th schedule, which Mr. Sibbal has shown, but those need to be summarized. One is the phrase original political party.
Just a moment.
This phrase is very important. Political party, oblique original political party. Now, I stopped at clause 4 of the 10th schedule. Till clause 4, if my counting is not wrong, this political party, original political party, has been used 8 times. 8 times. But there are many more. I'm just giving original political party, and sometimes they say political party in the same context. If your lordship sees 1C without reading it, it's been read to your lordship, but just keep it open with us. Then 21A, and these are hard, these are the operative provisions. An explanation. One C, 2(1)A, then explanation A. I'm sorry, my apology, was 2(1)B also. 2(1)B also. 2(1)A and 2(1)B. Then explanation A, explanation B, I, double I, actually much more than 8 actually. If you look at the sub-clauses. Then 2(2), then 4(I), and many times in clause 4. Now let's.
Interestingly, Dr. Singhvi, where does the expression original political party in 1C appear in the text of the 10th schedule?
Yes, yes.
Just as a matter of curiosity. I mean,
Yes.
nothing really would turn on this.
When they say
It's in 4. It's in 4. 4. 4.
4 in the merger,
Where is original political party merges with another?
the political party phrase in the other clauses means the same thing. I'll tell you in a minute why. Because the idea in a minute I'll come to it. It's the same concept. Now this is directly would be an issue on a subsequent date before the election commission, even on their reading of the symbols order. I'm not accepting the application, etc. All that is separate. On their reading, the symbols order clause.
Dr. Singhvi, can you just formulate the 4 elements and then you can
Yeah, I'm
briefly
sorry.
argue?
Yes. So
Because
the
just
first
help
is-
us in.
Yes. Number 2, of the 4 elements, the first is political party, the second, split group faction all out permanently from 2003 WEF 1104. Permanently out. That was the big balance pain because you created an anti-defection law. It was circumvented so easily. Therefore, and we have not yet heard, Your Lordship, not hearing the matter. If Your Lordship reads the statement of objects, it's very graphic to prevent precisely what is happening now. So, element number 2 of the 10th schedule, no form of split group or faction. Because that is directly what the election commission has to do.
Right.
Directly. In a minute, I'll show you. Number 3.
Directly?
That is exactly what the election commission is asked to do, the symbols order.
Okay.
I'm just saying, Wallace, it is suggested that Your Lordship is unrelated to issues. Hear this matter in November, let the election commission go on. Because how unreal would that be? Kindly consider. How duplicative, how irreversible. Number 3. And the statement of objects for this, when we come to the final hearing, will show that. There is a necessary condition and then there is a sufficient condition in 10th schedule. It's a cumulative combination. Now it is common ground, common I repeat, that the necessary condition may have happened, but the sufficient condition not alleged to have happened. What is the sufficient condition for this? You have to, inverted commas, not recognize, break away. And then, because now that there is no split, so more than 2/3 go, that means it's the new group. That group by itself makes no difference for 10th schedule. Let me give an extreme case. Out of 100, 90 go. Or 75. Unless the second sufficient condition is cumulatively satisfied, that is irrelevant. That is the whole purpose of the amendment. They have to merge or declare by merger, create a new political party. But only merge is the sole defense. Just bear with me on clause 4 for a minute. Just this needs to be there. Clause 4. That was the whole idea of substituting merger for split. It is nobody's case that in whatever form Shiva Sena exists there, in our whatever factions, that it has merged with the BJP. Now, a member of a house shall not be disqualified under 2(1). That's the only defense. It's an exemption. You will not be disqualified if this happens. It's like an exemption. member of a house shall not be disqualified under 2(1), where his original political party, the question Justice Chandra should ask, merges with another political party, and he claims that he and any other members of his original political party have become members of such other political party, or as the case may be, of a new political party formed after such merger, or have not accepted the merger and opted to function as a separate group. This will be for the balance 25 or 10 in my example. Because you've gone 75 have gone, 10 are left, 25 are left. And
So the people who remain after a merger,
that's right.
their entitlement to be legislators is not taken away.
Because
You are entitled to say, I don't form a part of the merger. I stay back and I continue with my own.
I'm very grateful, Manus. I'm very grateful. Because Manus, and quite right, it is not their fault. The remaining 10 can't be disqualified because 75 have gone with it. So that's a very logical. Now just continue the suffix. Suffix is important. And from the time of such merger, continues, such other political party or new political party or group as the case may be shall be deemed to be the political party to which he belongs for the purposes of sojourn. Now,
Deeming occurs subsequent. The deeming doesn't occur prior to our.
that's one of the important points of time. Absolutely right. So, Malas, merger is the only difference.
Yes.
Now, may I state the fourth one and then I'll make my submission. The fourth element is the election commission in some form will be deciding a majority. I'm using the word largely and loosely. Majority. My question to myself is, how does the election commission maintain a complaint by people who are not recognized under the defection law as a merged party? Number one.
Just a moment.
But they enter the door of the election commission. Look at the irony here. This is very interesting political irony here, which I'll come to in a minute. You can't maintain my complaint because you asked me at the door, who are you? How have you come here? Second, the election commission will decide majority by persons who, if they proceed, will be disqualified tomorrow. Well, can your lordship form any part of a majority if somebody is disqualified? Deciding this bunch of people is disqualified or not. They will be the same people who will be the majority considered by the EC and will be subsequently had to be disqualified. It is putting the cart before the horse. I don't understand why a constitution bench can't decide the basic issue and the election commission can wait. What is the value? What is the urgency? What is the balance of convenience? It is to make it irreversible. It is to make it a fait accompli. It is to then come and say, oh, then the constitutional authority which has decided. Now what is left? That is the real purpose.
All right. Yes, you got your 4 points. Mr.
Now,
Foxy, you go to the next point.
Just note for one thing. Well, if you are, what happens was there is a dilemma which is there. You have left the Shiv Sena, but you want to have the goodwill of the Shiv Sena. So you don't merge. Had you merged and knocked at the doors, it would be a new political party, subject to numbers. You want the best of both the worlds. You are admittedly claiming that you are the Shiv Sena, which is a concept not recognized in the 10th schedule. Where is it recognized? Anywhere. And you want to yet call us a Shiv Sena and yet say that no, you can go. Well, in what form? This is driving the coach and forth through this. And Wallace's fifth point is, this thing was enacted, Wallace, 15 years, 20 years after, on the Ayaram scourge, with a huge amount of discussion, and amended in 2003. We are talking of a largely a procedural construct of a symbols order, how the election commission will proceed.
Dr. Singhvi, you're right. Dr. Singhvi, you're right that the 10th schedule does not recognize who is the real who is the real party? Party A, you are the Shiv Sena.
Yes.
But is that a concept which is alien to the symbols order? No.
Well, it's-
The symbols order, who represents or who is the real party
Yes.
is not alien to the symbols order. You're right, because the 10th schedule is extremely tightly structured. The only defense is that of a merger. There is now no defense of a faction, of a split, of a one-third split. Yes.
Two answers. One answer is that assuming it is so, I'm not conceding that, I'm just answering a lot of two alternative points. That has to logically follow, not precede. It's the
See, let
first
me
point.
tell you what is really troubling is this.
Yes, yes.
The whole concept of disqualification is in relation to the House.
Yes.
All right. The jurisdiction of the Election Commission is to decide who represents the political party, right? Which of various factions represent the political party. The Election Commission exercises superintendence and control over the elections under 324, Article 324. What happens on the floor of the House is a microcosm of the consequence of the holding of an election.
Two or three answers. I appreciate
Right? That, so that is an area where, there is a little bit of constitutional thought to be done.
Answer number one. The Election Commission has to look at the legislative and the non-legislative wings of the party, decided by your lordships repeatedly, including the famous case of Saranja. That's answer number one. Your lordship should not be under the impression.
So your contention is that therefore, your contention really is that because the legislative wing of the party
Yes.
is brought under a cloud by virtue of the disqualification proceedings, therefore the Election Commission is necessarily then to be stultified or to be prevented, interdicted from exercising its jurisdiction in regard to the non-legislative part of the party. That's an area which is a little bit of
That is Sadiq Ali. Well, I were to appear in the Election Commission in single order cases. What they
In our compiling.
I just give one.
Three or four answers. Just kindly take this common convenience compilation. This will solve a lot of problems. There is this volume I have taken out of this. Your lordships have them taken out. Called common convenience volume. Just 2 or 3 pages. There
Old
are
one.
old one. Common convenience volume. Old one.
क्या मेन पेपर बुक में है सर? हाँ.
Two or three things here.
What are you showing, Dr. Singh?
Yes. First,
So we don't get identical. What exactly are you showing?
I am showing Willis in that volume, common compilation volume, the election commission notice at 698 page number.
1 minute.
Yes, sir.
What is the date of that?
Election commission is dated
Page 1853.
22nd July 2022.
1853.
22nd.
July 2022.
Dr. Singhvi, why don't you give us a PDF page?
That was meant for the main hearing, not for today. I should take a technical objection, but still that. Our training is still incomplete. That 22nd July.
What's the PDF number?
Now, Willis,
1853. Incidentally, for the record, it is page 1853 of the PDF pages.
185. Yeah, I'm ready.
Singhvi, at 12 sharp, we'll wrap up with your side. We'll give you another 5 minutes, and
Yes,
so that
that'd be very.
we'll just take a short break, a comfort break, and we'll return to hear the arguments of the respondents
So,
after.
Willis, let me be very pointed. Now, this page, which your lordship has got the PDF of, the notice itself, as in all election matters, the symbol matters of the election commission. See the last page, 702. Mother, I'm sorry, I'm not able to assist you. 3 pages later. The last but one paragraph.
1857.
Yes. Require, well, just see the top paragraph. Prior to the hearing of the two rival groups, if any, inter alia require both rival groups to submit their respective documentary evidence of support claimed by them in the organizational and legislative wings of the party. That page I'm asking Lordship to underline. Now, let's very quickly, if your Lordship doesn't mind, going back to my page 684, which should be about 10 pages out here. PDF page, no PDF. My learned opponents for this filing in the EC is very revealing. What they filed. That starts at my page 670.
Interestingly, both sides in their written submissions have referred to the pleadings of the other. What the other side, when you filed your pleadings, both of you didn't have an idea of this thing that is going to now happen
I
here.
have said anything very seriously wrong, but this is very interesting what they have said. Kindly see 684.
684.
Yes. It's para 23, small Roman 23.
Yeah.
It is submitted that the petitioner, now this is the petitioner, the other side, presently enjoys the support of 40 out of 55 MLAs of the Shiv Sena. This is directly another issue. There is no question of 40 out of 55 disqualified people. In the Maharashtra Assembly, a resolution dated 26th of June passed by 40 MLAs reaffirming their support and faith in the petitioner and the main leader to the next. That's point.
But can the EC proceed on a demurrer that assuming that these 40 persons are not to be taken into account in determining who represents, which faction represents the Sena,
Then the petition
even so?
that petition can't be filed. So there's no such thing. The petition can't be filed because the approach is all details of organizational and legislative, and just these 2 pages later, 687.
687.
2 pages. Because the filer, the approacher is Mr. Shinde. He is not a member of the Legislative Assembly. Is he not claiming on the basis of the Legislative Assembly status?
Right. Page 687.
Now, 687, on the top fourth line, organizational and legislative wings of the party. Fourth line, para 9, on the top of the page. Then para 10, next para, fourth line, all layers of organization as well as legislation wings. I can multiply this now because my time is short, so please come to Sadiq Ali. The citation is 1974, 1972, volume 4 SCC. 1972, volume 4 SCC. 664. What document
Now, I think that is the.
document my lord is reading has been filed by a sole person, Mr. Eknath Shinde, whose only
Right.
status is that of a supposed MLA of the Shiv Sena, is what I will say. Now,
Are you now reading Sadiq Ali?
Sadiq Ali, para
I think Sadiq Ali is part of the convenience
yes,
compilation.
page 14 of their convenience compilation, the other side. Your lordship can get it in so many forms.
Just give us a moment. Doctor.
Para 26 there is. As your lordship knows, this judgment has stood the test of time, even though it is
Election
communicating on
Election
comparison of election commission.
Yeah, I just saw it.
I'm getting. Well, I am only on the point that there is a huge overlap, direct interconnection. Your lordship is deciding.
Yes, Doctor. We've
That's
got
why
it.
I'm not concerned about the final merits.
Very
Your lordship is so like it's a North Pole, South Pole apart. It's two unrelated issues. That's what I'm objecting to. As if they're two unrelated issues. Now, just see what is in their complaint, in Mr. Shinde's status, in their pleadings, they say, I have so many MLAs, I have so many MLAs. Now read this judgment. An election commission says legislative organization. Now read the judgment, para 26.
Para 26.
26, which is at page 677. The figures found by the commission of the members of the two houses of parliament and of the state legislatures, as well as those of AICC members and delegates who supported Congress J, have not been shown to us to be incorrect. It is in view of those figures, it can hardly be disputed that substantial majority of the members of the Congress in both its legislative wing as well as organizational wing supported by Congress J. That's why the same phrase is used in the notice of the election commission. Same phrase. As Congress is a democratic organization, the test of majority and numerical strength in our opinion is very valuable and relevant test. Then they go on. This is, of course, 68 is 15 years prior or 20 years prior to state review. Judgment is prior, but I'm at the moment of the judgment's own terms. Can you separate? Can you, you are told that this is unrelated issue. Then also note para 29, the last 4 lines. Majority of Houses of Parliament and sum total of members of state legislature. Last 2 lines of para 29 to save time. Last 2 lines of para 29. In any case. Last 2 lines of 29.
In any case.
3 lines. Now this third aspect. Symbols order, which is very important to repeat, predates by 15, 20 years, 17 years, is premised upon not a disqualification situation. It is premised upon a dispute. Because we are one group, we have a fight. He says, I want the symbol, I say, I want the symbol. It never contemplated the penal consequence of him being disqualified or being disqualified. It did not even enter their mind.
Correct.
Therefore, this was premised on the legislative wing. The logically prior stage has to be the disqualification. That is logically prior. Number 4, Malas, your lordship uses this phrase, it has become a commonplace, but it is a lot of weight. Not when the Supreme Court uses it alone, even lower courts. What is the meaning of the subject to outcome? We just say it like that. Your lordship will find the IIM, yes, your lordship says that. The idea is, look, I'm putting you on warning. You will claim equities because I may ultimately hold this way or that way. Now, this is the hiatus between them is several months.
All right, Dr. Singhvi, thanks. Can we wrap up on this?
Yes, I'm done with this. Because I want to only say one thing, that your lordship will keep in mind also this concept of voluntarily gives up. Voluntarily gives up is a very important phrase, which your lordship finds in 2.1a, inter alia. How do you voluntarily give up? You voluntarily give up when you don't satisfy the conditions of the schedule. Suppose I expel you. Then, of course, you are not voluntarily giving. That's why I said, in the actual reality of political life, expulsion is welcome sometimes. It is a welcome. But, if you do some activity which is subject to disqualification and you leave and you proclaim yourself as a separate group, but don't merge, you have voluntarily given up membership. Because if you have given up membership, with greatest respect, how does para 15 apply? That too by the sole applicant before the election commission, Mr. Eknath Shinde. Who's the sole applicant? There is no other application. Today, your lordships can always decide. But today, he is under a cloud, under the simple text of 2.1a.
All right, Dr. Singhvi, thank you very much. We'll just take a short break and we'll be back and we'll hear these. Yeah.
Balance of convenience of lordship doesn't have any impression that your lordship has some imminence or urgency.
Mr. Sibal made the point. We saw the of those orders. We can just see those for a moment. That's all that we'll share.
That's a different matter. The option is it exists, is what I'm saying.
This will be
All right.
We direct, there are 3 enough. We direct the parties.
All right.